looked at by their people. Do you think it's, and it comes to a second issue which was brought up by Ms Clemmons about the standards acceptable at football stadium and out with football stadia, do you believe that we are in a situation where we can't afford to do anything with this? Where do we go with this? What would you like us to do with this actual legislation? Because if the European governing body don't like what's happening, surely that puts us in a bit of an awkward place.
Professor Devine, yes.
Yes. We've got to remember how specific the reaction of the so-called European governing body, UEFA, was. Those songs that it condemned and then fined a football team for, or a football club for, would have been found to be also wrong and punishable in Scots law, existing Scots law. Those fines were because of manifestations of religious hatred, not in any way to do with the catch-all nature of this proposed legislation. And that's why those who gave evidence to UEFA, especially on the first occasion, who gave academic evidence to UEFA in relation to a particular song, which many around this table will know of, which is crassly anti-sectarian, which is crassly anti-Catholic. That was the reason why the judges had no difficulty coming to a conclusion, because it was a clear-cut case. The issue of offensive behaviour is by no means clear-cut. You have continuously asked witnesses throughout this process to define what these mean. And intellectually, I think, my personal view is, the answers have been unconvincing.
Should the Lord Advocate, when the Lord Advocate produces these long-awaited guidelines, well, we can hardly say will they be useful if we can't see them, but should they be more than guidelines? And guidelines will be persuasive, presumably to police and to courts. Should they be something other than guidelines, something more into statute? Would you feel that that would give this less broad catch? You say it's a catch-all.
Well, I mean, the problem I have, Convener, is that intellectually and in terms of any empirical evidence I have, I'm opposed to this legislation, except for the second area, which is a new development in our society in relation to electronic communications. I think that is certainly well worth considering and looking at and producing robust law. It's the first one that I've got a major problem with, because in my view, the very tightly written legislation of 2003 covers most of the areas at these matches where there is no ambiguity. The problem you're going to get into, for example, is if, to take an illustration, if Celtic supporters go down to Manchester United and sing songs which they think deal with Irish freedom or oppression by the British state, is that offensive, or is it a statement of political belief? This is the difficult territory intellectually that this proposed legislation has entered, and is in danger, in my view, of bringing Scots law in this particular area into possible disrepute.
Thank you for that. Roderick, you wanted to come in on this.
Actually, touching on what I was about to try and explore further, I was interested in your reference to what happened in the Perth Sheriff Court and to what we're developing, and indeed one or two other people in their submissions have distinguished between political sectarianism and religious sectarianism. And from what you're saying, although you're opposed to the bill generally, I think you would be cautioning this committee from passing legislation which clearly did not allow for statements of political belief.
Well, I mean, I think the term political sectarianism is a contradiction in terms. Sectarianism, in the definition, is evincing religious hatred or hatred to another group either in writing, by other form of communication, singing, etc., because of that individual or that group's religious belief. It's a dead easy definition, and that's why, as I say, on that occasion, the Sheriff had no difficulty in coming to a determination at the end. Can I just refer back to a witness that appeared earlier, one of the police witnesses, who said that as far as he could see from his experience, most of these offences took place in and around football grounds. Some of you may be aware of the fact that there was a research project, albeit minimalist research project, carried out on the cases which were found in relation to the 2003 reformed legislation. I think it was over a six-month period from 2003, the cases were examined for those who were found guilty or were arraigned by procurator fiscals for sectarian-related breach of the peace. And according to the evidence, and as you probably know, Frank Mulholland, the Lord Advocate, or the former Lord Advocate, present Lord Advocate, previous Solicitor General, has a team looking at these data, covering the entire period from 2003 to the present. The findings of which could be extraordinarily interesting and potentially explosive. But anyway, the point I'm going to make is this. In 14% of the cases examined, it was possible to identify that the incident related specifically to football or the support of a particular team. In other words, far from being consistent with the assertions made by the police officer earlier today, in terms of these data, and it's one of the few areas of hard data we have for this kind of thing, a very, very small minority of cases were related to that particular experience. There is one caveat, of course, Convener. It could well be that because of the size of the crowds present at these events, the police felt impotent to intervene, and therefore the sectarian breach, if you like, the public sectarian breach went on.
I think there was a question asked a few moments ago about where we should go with this legislation in relation to the European positions. And I do think there is a case for saying that we should keep the focus slightly wider to religious hatred rather than the narrower sectarianism, because we live in a multi-religious society. And some of the conversations I've had about Church of Scotland work is interfaith work, and the tensions people see in communities are actually not all, but between different Christian groups. And I think we would lose a lot if we focus too much on that and don't accept that there are other issues that may be relevant here.
But I think that the issue we have in Scotland, what distinguishes the Scottish experience from other jurisdictions throughout the world, it's probably well known that this problem is to a large extent rooted in Irish Catholic and Irish Protestant migration in the 19th and early 20th centuries. Yet, of all the jurisdictions where the Irish of each faith tradition settled, Scotland is the only jurisdiction in the world which has on the statute book anti-sectarian legislation. That suggests to me that Scotland has a distinctive and special problem in relation to the original issue which caused the McConnell government to move into this area. And my fear is if you spread and dilute, you will lose the focus on what I would call not Scotland's shame, but the Scottish problem, which needs to be tackled not simply by legislation, of course, but legislation can help, but by a variety of other means as well. This bill almost moves into what I would call umbrella territory and is in danger of losing that specific focus on the particular Scottish problem that we have.
Anyone else in the panel want to comment on this particular before I go back to members? I've got Hamza next, please.
Well, I think we would take a similar position to Professor Devine. I think if this legislation is responding to a particular problem, then I think that should be the focus of it. I think we do live in a particular time when people are very sensitive to not offending anyone, and there seems to be perhaps a reluctance to focus in on what the issue is here in sectarianism and to define exactly what it is. And It's understandable, and it's good intentions behind it, but to just have this a broad umbrella of, well, let's tackle every single possible prejudice in this bill, moves it away from what we believe it was created for, which was to deal with the bigotry that arises at football matches.
Can I just say one other thing? My sense from what I've heard from Mulholland's office is that the release of these data and the analysis of these data that are referred to, which deal with the occupation, the territory, the religious affiliation of victims and defenders, supposing this material analysed comes out and finds that overwhelmingly, massively, victims come from a certain religious background and the aggressor, if you want to call it that, comes from a different religious background. Now that presents both government and Parliament with a particular issue, because again I say that we lack hard data on these areas. It's what I call, in terms of my definition of sectarianism, structural sectarianism has gone. The labour market discrimination, which affected life chances of people, has gone. But there remains attitudinal sectarianism, sometimes bigotry as defined, which is unpleasant, can sometimes actually lead to violence, but is still with us, at least in certain parts of Scotland. Patchy, the quite truly incredible evidence I heard given by a sociologist from a university in Dundee a few days ago. I wasn't actually physically present. I just saw it on my computer, denying that attitudinal sectarianism is not an issue in this country.
That would be, I think, Dr. Waiton's evidence you're referring to. Can I ask you, I'm going to move on to Hamza, but given your position with regard to this, just say collectively, do you feel the legislation would be provocative as comes? And let's park the IT part of it, but the offensive behaviour at the football match, do you think that it would therefore be provocative if it came in and be therefore counterproductive?
Can I just say very quickly, and then I'll very briefly, let my colleagues follow me, but 2 points very quickly. One is that there's a danger here, possibly in fact an inevitability, that you will make certain behaviour criminal, which wasn't criminal under the 2003 Act. There's certain people who don't regard themselves as behaving in a criminal way might react in a particular way to that. And the second thing, the second aspect of it, which I think is equally important, if it's not going to be inflammatory, it's going to be incredibly controversial.
I'm just going to move on. So nobody else is indicating, man, I've got a queue of members wanting to ask questions. Hamza, John, Finney, and then Graham.
Thank you for coming along to the session. My point is to do with the legislation also, I suppose, and a follow-up from Ms Clemmons' submission and your organisation's submission. It seemed quite critical of the fact that there's being any legislation being drawn up in the first place. Kind of reflected what we heard last week by the Supporters Trust. In your submission, you say the bill will do nothing to reduce sectarianism unless it's part of wider work, which I agree, actually, wider work, but I think there's wider work going on. The conviction of a sectarian offence could be seen as a badge of honour, and I understand you're just reflecting your consultation you had with others. The same thing was often said about racist and anti-racism measures and legislation, but it was found imperative that it be introduced. I also want to bring in Dr Keegoodle's submission, which we'll be hearing from later on, and her research also suggests that law can influence people to reduce overt prejudice and can even change attitudes through changing their behaviour. Do you then think that the legislation, because I think there's been an understanding that there's been a collective failure among politicians, governments, football clubs, and even civic organisations in actually confronting this, then is there not really a need for some kind of legislation?
Yes, we do think there is a need for legislation, and we absolutely agree that the behaviour is unacceptable and that something needs to be done about it. We think the problem is that legislation will apply equally to everybody, And some people perceive legislation as something that is a positive part of their lives, something that they would seek to be law-abiding, seek to engage with. Some people don't perceive legislation that way. So the effect that you have on some people will be different to that you have on other people. And the experience of a number